Welcome back to the deep dive. Today, we are wading into some very tricky waters in tort law. Proximate cause.
Right.
We're not just talking about simple cause and effect. We're interested in that specific moment where the law just, well, draws a line and says, that's far enough.
Exactly.
Our mission today is to give you a really solid analytical framework for superseding intervening causes. You know, that moment when a second, totally separate negligent act comes into the picture and might just break the chain of liability.
And that's really the heart of it. Proximate cause is the ultimate gatekeeper doctrine. It's where the law stops being about physics. Did this cause that? And becomes pure policy. It starts asking, is it actually fair to hold this person responsible?
Yeah. Okay.
So we're going to define the policy behind this. Then we'll tear apart the landmark case, Ventricelli v. Kinney system, rent a car, to see exactly how courts use this idea of foreseeability as a tool to either pin liability on someone or let them off.
Okay, let's start with that foundational question then. We all get but-for causation. If the accident wouldn't have happened but for your negligence, you're a cause. Simple. But what does the law really mean by proximate cause? And why does it even exist to let a negligent person off the hook?
Well, because without it, liability would be infinite. I mean, think about it. Proximate cause is a judicial limit. It's driven entirely by policy and, frankly, common sense.
A limit.
Yeah. The great legal scholar Prosser famously said it's often nothing more than a convenient formula for disposing of the case. It's motivated by convenience, public policy, and just a rough sense of justice.
So it's really a policy decision dressed up as a legal test. If I start a small fire and a mile down the road someone crashes their car because they were staring at the smoke, my negligence is a but-for cause of that crash.
It is, absolutely. But the law has to be able to step in and say, hold on, that outcome is just too remote, too bizarre. And the key rule here, the phrase you'll always hear, is that the harm has to be within the range of reasonable apprehension. And if another act happens, a second negligent act, the court has to decide if that second act was so strange or so extraordinary that it becomes a superseding intervening cause.
And if it is?
It snaps the chain. The first negligent person is off the hook. The moment a court says something was unforeseeable, what they're really doing is making a policy decision to cap liability.
This is fascinating. To really understand where that line gets drawn, we have to look at this case. Let's analyze Ventricelli v. Kinney system, rent-a-car. First, what are the legally dispositive facts? What really mattered here?
Okay, the facts are absolutely key. The plaintiff, Ventricelli, rented a car from Kinney. The problem was the trunk lid. It was defective, and it just wouldn't stay closed, even after they tried to fix it a few times.
So, a known defect.
A known, persistent defect. So the plaintiff pulls over and parks his car on Mott Street in the city. He gets out, and he's standing behind the car with a passenger, trying over and over to slam the trunk shut. Then, out of nowhere, a second car that had been parked a few lengths behind them, driven by a Mr. Maldonado, suddenly lurches forward and hits him, injuring him badly.
And what was the core legal issue for the court?
The precise issue was whether Kinney's negligence, giving him a car with a broken trunk, was the proximate cause of his injuries, or was the second driver's act of suddenly jumping forward so unforeseeable that it constituted a superseding intervening cause.
What rule of law did the court apply here? Please state the full black-letter rule and break it down into its testable elements.
The court applied the rule that proximate cause requires the harm to be a reasonably foreseeable result of the defendant's negligence. And when you have an intervening force like the second car, this test really splits into two distinct elements the court has to check off.
Okay, two elements.
First, the foreseeability of the plaintiff's act. Was the general thing the plaintiff was doing, stopping his car to try and fix the defective trunk, a foreseeable consequence of the defect? And second, the foreseeability of the intervening force. Was the specific thing that happened, the collision from Maldonado's car, a foreseeable risk that arose from the plaintiff trying to fix the trunk?
I have to stop you there because that feels a little like the court is trying to have it both ways. They gave him a broken car. Of course he's going to try to fix it. And if you're forced to stop on a city street to fix your car, isn't the risk of traffic and getting hit by another car one of the most basic foreseeable risks there is?
That is the million-dollar question. And it's exactly the point the dissent makes. It just shows you how much policy, not physics, is driving this entire doctrine. But let's walk through the majority's logic.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, foreseeability of the plaintiff's act?
So for that first element, the court actually agreed with the plaintiff. They said yes, it was completely foreseeable. They found that the negligence in providing a defective trunk would naturally and reasonably result in the plaintiff's repeated attempts to close the lid. So that first link in the chain was established. Kinney's negligence was a cause of the accident.
Understood. So he was foreseeably trying to fix the defect. Now, for the critical second element, foreseeability of the specific injury, that collision with Maldonado's car. How did the court use policy to shut down liability on this point?
This is where the majority drew its line in the sand. They ruled this second element was not met. The court decided that a collision between two cars, both of which were parked a brief interval before the accident, was simply not foreseeable as a result of a broken trunk lid.
And their reasoning for that.
The reasoning was all about location.
Yeah.
The policy lever they pulled.
Location.
Exactly. The court kept stressing that the plaintiff was in a safe place, a designated parking space, not out in a lane of traffic. They even argued that, hey, this kind of accident could have happened anyway, even if the trunk wasn't broken. What if he was just loading groceries?
I see.
The policy concern was that holding the rental company liable for every random act of negligence that happens near one of their parked cars would, in their words, stretch the concept of foreseeability beyond acceptable limits. They used his location to justify cutting off liability.
And after analyzing all the elements, what was the court's final conclusion?
The court concluded that Kinney's negligence was not the proximate cause of the injury. Maldonado's sudden, bizarre jump forward was the immediately effective cause. They labeled it a superseding intervening cause, and that severed the chain of liability right there. Kinney was off the hook.
It's just amazing how fine that line is. And the court was split. The dissent, led by Judge Fuchsberg, argued this was completely wrong. How did the dissent make its case?
The dissent basically said this is a question for the jury, not for judges to decide as a matter of law. Judge Fuchsberg's point was that Kinney knew the trunk had a penchant for flying open and blocking the driver's view. So it was a most reasonable rather than a remote expectation that the driver would have to get out and fix it somewhere.
So the dissent is focusing on the risk itself, that the negligence didn't just put the victim in a certain location, it actively increased the chance of this specific kind of harm happening.
That's it, exactly. The dissent argued that Kinney's negligence increased the occasions for such risks. A driver with a broken trunk has to stop near traffic to fix it. So the injury, even though it was caused by the second car, wouldn't have happened otherwise. The dissent thought a jury could easily find the collision was an ordinary and natural result of the original negligence.
Okay, that distinction is critical. Let's use a visceral hypothetical to really lock this in. Say a company negligently installs a rusty seatbelt. The driver gets into a minor fender bender. He panics because the rusty belt is jammed, so he crawls out the window, stands on the curb, and is immediately struck by a meteorite. Is the company liable?
A great hypothetical. And no, the company would almost certainly not be liable. It comes down to the type of risk created.
Explain that.
The rusty seatbelt created a foreseeable risk of injury from a failed safety device in a crash. It did not create a foreseeable risk of getting hit by an object from outer space.
But wait, the company's negligence is still a but-for cause, isn't it? He wouldn't have been standing on that exact spot at that exact second but for the jammed seatbelt.
100%. It's a clear cause, in fact. But the meteorite is the ultimate unforeseeable, independent, extraordinary intervening force. The specific injury has no logical connection to the risk the defendant created. That foreseeability element fails completely, and it reinforces the Ventricelli principle. The injury has to flow from the danger the defendant created, not just from the location their negligence put the plaintiff in.
That really clarifies it. The specific risk has to be the one that comes true. So what does this all mean for you, the listener, when you're analyzing a fact pattern with two negligent acts? Give us that actionable step-by-step checklist.
Okay, to do this right every time, you have to be rigorous. Follow this 5-step diagnostic path.
Step 1.
Step 1. Original negligence and duty. Just confirm the first defendant was actually negligent and breached a duty. Kinney clearly did. They had to provide a safe car.
Okay. Step 2.
Step 2. Cause and fact. Ask the but-for question. Would the injury have happened when and where it did, but for the defendant's negligence? If no, you have cause and fact. Step 3. Proximate cause, the risk type. Now you apply the foreseeability test. Did the defendant's negligence create a risk of the general type of harm that happened? Risk of getting hit by a car, harm is getting hit by a car, you move on. Risk of seatbelt failure, harm is meteorite, you stop.
And 4.
Step 4, intervening force analysis. Identify that second negligent act, Maldonado's jump. Ask yourself, was this specific force, in the way it happened, reasonably foreseeable back when the original negligence occurred.
And finally, the conclusion.
Step 5. The superseding conclusion. This is where you make the call. If that intervening force seems abnormal, extraordinary, or totally independent like the majority in Ventricelli found, it's a superseding cause. It breaks the chain. If it seems like a normal consequence of the risk the defendant created, like the dissent argued, then liability remains.
That framework is incredibly helpful. It cuts right through the noise. The Ventricelli case really is a powerful reminder that while cause, in fact, is about science, proximate cause is purely a judicial policy call about fairness.
It is. And that policy call, as we saw, can hinge on one tiny detail, like the location of the victim. The court went to great lengths to call the parking space a relatively safe place.
Right.
So here's a final thought for you to chew on. What if the trunk defect had made the car totally inoperable, forcing the plaintiff to stop in an active lane of traffic? Could the court still have used that safe location policy lever to let Kinney off the hook? Or would the collision then have become an unavoidable, ordinary, and natural result of the negligence? The proximity of the danger is what defines the orbit of the duty.